inside of this, baby. Maybe I went through all the papers, and after making me wait for 1.5 hours, they just said, "Oh, we're sorry. There is an issue processing my application, and I don't know what the issue is."
Wow! The crying, the drama, the overacting, that's just quite amazing. Hi, my name is Cameron. I'm a former fraud prevention officer, and I'm going to reveal how realistic the immigration of Fiancé that I can't say, and I'm going to have to record this take again because I didn't get my lines right. Wow, okay, hello. My name is Cameron. I'm a former fraud prevention officer, and I'm going to go over how realistic the 90-day fiancé really is. Is it based on law, or is it just pure fiction? Let's see what happens. The premise of the show is that it follows an American who wishes to marry a foreign spouse and bring them to the U.S. Except instead of marrying them in this foreign spouse's home country, which was the tradition for these types of couples, the American is able to petition, and specifically file a I-129F petition, to bring their foreign lover to the United States and marry them here. They are able to do that through what's called a K-1 fiancé visa. This visa was added to the Immigration Nationality Act in 1970, specifically to help American soldiers in Vietnam bring back their Vietnamese partners to the United States sooner. So why 90 days? Because that's what the law says. Specifically, Title 8 CFR, Section 214.2, Subsection K, Paragraph 3, Subparagraph I, states, the petition must be accompanied by evidence that the petitioner and the beneficiary have a bona fide intention to marry, and that they are legally able to and actually willing to conclude a valid marriage in the United States within 90 days of the beneficiary's arrival. So yes, the intention to get married within 90 days is very real. In fact, the law states that if you don't get married within 90 days, the visa becomes invalid and the beneficiary must return to their home country. Now, there are exceptions to this. One of the most common ones is a VAWA petition, that is the Violence Against Women's Act. The petitioner may self-file for their adjustment of status if they can prove that they were abused. Now, it's not as easy as it sounds. The burden of proof is actually very high, and USCIS is very aware that some unscrupulous beneficiaries do use this to try to get around actually having to marry the guy. That being said, some petitioners say the VAWA process is unfair since the beneficiary doesn't need physical evidence to prove that she was abused, and that by law he cannot defend himself. The Violence Against Women Act specifically states that all evidence related to VAWA self-petition is kept strictly confidential under 8 U.S. Code Section 1367. This means the U.S. citizen petitioner is not notified, cannot even see the allegation, and has no legal right to respond or challenge the claim, even if it's false. Now, if you're like me, you're probably wondering, doesn't that violate the 6th Amendment, which guarantees the right of someone to confront their accuser? Well, it's because technically, VAWA self-petition is not a criminal case, it's a civil immigration act, and therefore they say that it doesn't violate the guy's 6th Amendment rights because he can't go to prison. It's just about whether or not to allow the woman to, or guy, to self-petition to come into the United States. I think it is a violation of the spirit of the 6th Amendment, but so far it has not been challenged and it has not gone to the Supreme Court, at least, to be here. But I would be very curious to see how the Supreme Court rules on that. But this is getting esoteric. Sorry, back to the video. So who qualifies for a K-1 visa? Okay, so there are a few basic requirements. 1, the petitioner must be a U.S. citizen. 2, the U.S. citizen must prove that they have the ability to take care of this person. So they do that through establishing that your income is at least 125% of the federal poverty guideline. And honestly, you could make that income requirement by working at McDonald's full time because it's just $21,000. So they're pretty generous with that. And both the beneficiary and the petitioner must be legally free to marry, i.e., they cannot be married to someone else. So if you are divorced, part of your application will be your divorce decree, as well as if the beneficiary is divorced or annulled, she will need to include that as well, because that would obviously be bigamy. You can't be married to two people at once. This is actually a big deal and a big problem for Filipino beneficiaries because there is no divorce in the Philippines and annulment is extremely difficult to get. But unfortunately, that's a bar. Even if she has been separated from her partner for 20 years, if the marriage is not legally annulled, you cannot petition her under a K-1 visa. And yes, they do check. In addition, there are some legal barriers. So criminal history specifically. If the petitioner has been convicted of a crime against a minor, specific crimes like sexual offenses, kidnapping, stuff like that, that is an automatic bar under the Adam Walsh Act. There are extremely difficult circumstances in which you can get a waiver, but I can tell you those are almost never approved, and by almost never, I mean never approved. Additionally, if the petitioner has been convicted of domestic violence, anything that has to do with violence, that is going to cause extra scrutiny and delays in the application. Not an automatic bar, but you really need to make sure your petition is very strong to overcome any violent criminal convictions that you have. Even if they've been expunged, expunged means nothing. USCIS can still see it, so you've got to be prepared. That's where someone like me would come in to help you make sure that your petition is ready to go and can stand up to increased scrutiny. Another common theme that I see implied in 90 Day Fiancé is if the petitioner is not happy with the foreign national, that the petitioner, the U.S. citizen, can just send the foreign national back. It doesn't work that way. Foreign nationals are not toys. You can't return them to sender if you're not happy with them. You can decline to marry them, and then they may have to go back. But you can't just send them back. You can't deport them yourself. USCIS has to deport them. And because of the backlog in the immigration court system, it could be years before they are deported, if they ever are deported at all. So you can decline to marry them, but you actually are still on the hook to support them, because part of the K-1 petition is an affidavit of support, where you agree to be legally responsible to support the person for 10 years, even if they don't marry you. So if it doesn't work out, and then all of a sudden you guys go your separate ways and she files on welfare, the government could, in theory, go after you to reimburse them for the money they spent on welfare for the beneficiary. I will say it does not happen that much. However, under the Trump administration, new proposals for the public charge rule, that's what it's called, are going to be more strictly enforced. So you got to be really careful where you bring someone over here. So what else does 90 Day Fiancé get wrong? Well, for one thing, the show ends after the couple gets married. They act like, oh, it's happily ever after. Well, no. Getting married is just half the battle. Once you get married, you have to go through an expensive adjustment of status process. You have to file Form I-485, and that's $1,400 in government fees. So that's if you do it yourself and you don't get someone else to help you. Overall, this is a very expensive process. If you do it yourself, once you factor in the I-129F petition fees, the medical exam, the U.S. Embassy fees, everything else, you're probably looking at about $2,000. That's if you do it yourself. If you get help, you're probably looking at closer to $3,000 to $4,000, even $5,000, depending upon what help you get. Additionally, so once you do the adjustment of status, you may have to do another interview. That's if they suspect fraud. Most of the time, the interview is waived, so that's a good thing. The reason they do the conditional green card is because, remember I told you that the visa was for soldiers to bring their Vietnamese lovers back to America? Well, the problem was that once a lot of those women got their green cards, like, would dump the American. And so they actually testified in Congress how hurt they were. They thought the relationship was real, but she was just after a green card. So they passed amendments in 1986 to the Immigration Nationality Act, the INA, which added the 2-year waiting period. And this is to protect the American citizens from foreign nationals who specifically use them for a green card. So if they divorce you within the 2 years, chances are higher they will be deported. Now, there are exceptions to this, as I already talked about, the VAWA, but again, don't let that scare you. That is not as easy to get as some critics make it sound. The USCIS knows that this is a common fraud pattern, but it is there. Those are some of the big things. So what they get right is the emotional tension. There's a lot of emotional conflict, intercultural conflict, especially as surprising as in the Philippines, because a lot of Americans think that, oh, it's just a poor version of Hawaii because they speak English. They speak English, but it's not just a poor version of Hawaii. You're talking about different culture with different history and different values and different expectations. So I'm just going to tell you straight up from my years of processing visas, if you are going to marry a Filipina, for the most part, not all, the expectation is that you are going to take care of her and throw some bones her family's way. Now, that doesn't make her bad, and it doesn't mean she's a gold digger. That's just the way it works. The guy gets youth, loyalty, and the lady gets a ticket out of poverty for herself and to help her family out. There's nothing wrong with that. And a lot of marriages in the past were like this. It wasn't a big deal. It's mostly younger men that seem to have a problem with this. So that's why I'm just going to be honest with you and tell you straight up, if you are a younger man or any man, and you want to marry somebody and you're looking for a 50-50 down the middle split, you're paying your half, she's paying her half, chances are you ain't going to get it in the Philippines. You probably want to go to Japan, Singapore, something like that. But most men who want to marry a Filipina are okay with traditional marriage. And you should be too. You can find exceptions, of course, but I'm saying for the most part. If you do want to do this process, you need to have money and patience. Those are the two most important things you need if you want to do a K-1 visa process. That being said, I have to tell you, most guys I know who are married to Filipinos are very happy. Just those who are complaining on the internet, I'm not trying to disparage their experience, but that's a vocal minority. I've been doing this for many years, and most of the men are extremely happy, and most of them tell me this is the happiest they've ever been. So, if you are interested in having help with your K-1 petition, you can book a consultation with me at busybodivisa.com or use the link in the description. Thank you very much. Have a blessed day.